Hi everyone, I'm immigration attorney John Khosravi, joining you today from Los Angeles, California, my hometown and headquarters, to take your questions live about U.S. immigration law. We do this every week over a year now, every Wednesday, nowadays at 6 p.m. Pacific time, where you come in and ask general questions and I can provide general educational comments. Quick note, I lost my voice yesterday. Hopefully I can keep it throughout the next 30-40 minutes. But right now it doesn't look good. As soon as I started, my throat's giving away. So I'll have to talk more gently, which I'm sure y'all like more because I've been told many times that I talk way too fast on the show. So you got your wishes and your requests answered. I'll have to talk slower just so I don't burn out my throat. But thank you all for joining us. We're going to take your general education questions. And also, we have a free consultation giveaway, or 3 of them every 10 minutes for those that are watching the live program. If you like, subscribe, and leave a comment like consultation, my assistant Katrina will choose a random person every 10 minutes for the next half hour. Just say, hey, you get a free video 15-minute consultation where you can generally discuss your case, see what's going on in a more private setting. So keep that in mind as we go into it, and with that, let's get it started. I want to make note that USCIS has decided to extend the automatic extension period for Form I-751 filings. What does this mean? Well, if you've been married, if you got your green card through marriage, and the green card you got was a 2-year conditional green card, nearing the 2-year mark, you have to apply for a renewal or an extension of that 2-year green card. Now, the process for this should take 3-4 months, but in reality, it's taking like 1 to 2 years in most cases, and it creates difficulty. So originally, having an expired green card is taking so long, it's difficulty. What USCIS did is they said we'll give an automatic 18-month extension once you file the Form I-751, so that you will be able to live and work and have proof of residency while the case is pending. But they're taking so much longer that they now upped it to 2 years automatic extension. So that's good, because what would happen before, and for a lot of people who have the case pending, once the 1.5 years comes up, they lose their extension, and then they have to go to USCIS to request an extension stamp, we call it added stamp, ADIT, and it's a lot of work, it's hard to get, and so they're trying to be helpful. So it's a plus on one side, but it's a negative, meaning they plan on these delays to continue, which is horrible. And you see this actually with the medical checkup. So when you adjust status in the United States, you have to go to a civil surgeon, and they do a checkup on you, and that checkup was usually valid for 2 years. They've increased it temporarily for a 4-year validity. So, that's good. So the case is taking too long, you don't have to do a new medical. But on the other side, why are they doing that? That means they're expecting cases to take much longer than they were. So that's what we're seeing with USCIS. The fiscal year is going to end, the annual year, as the government does, it ends at the end of September. A lot of people who didn't get the diversity visa lottery are going to lose out, unfortunately. But most likely in October, we're going to see a big jump forward in the visa bulletin for those doing employment-based green cards. They may have the opportunity to finally start their case, their green card case, or finish it actually. Now, as he asks, hi John, if I sponsor my brother, will I need an affidavit of support for my brother? If yes, when will I need to file? I'm a U.S. citizen. That's a great question. So this is the F4 preference category, a U.S. citizen filing for their sibling. You initially have to file the Form I-130 petition for alien relative and have your birth certificates and stuff to show that you have the same parents. And then that's going to be approved eventually. Maybe take 10 years for them to even review it. But you don't need to do the affidavit of support until the time comes for your brother to start his embassy processing, which is not going to happen for at least 15 years in most cases after you start the case. It could be longer if your brother's from the Philippines or China or somewhere, or Mexico. So when the embassy process, known as consular processing, begins, that's when you need to submit an affidavit of support. I don't know if you start your case or if you're going to start it, but it's not going to happen anytime soon until that time. For now, the affidavit of support and all the requirements are not necessary or involved in the immigration process until consular processing begins. You'll get a message from the National Visa Center, or NVC for short, and they'll give you the login info to go on the website for the government and upload these documents, and that's when you get that started. But thank you for your question, Azia. Mike asks, for K-1 applications, do the couples submit separate letters of intent to marry, or they write just one and both sign the same letter? I don't know what the exact requirements are, if you need to do one or two, but I always do two. Just do two separate letters, make it very clear so who's signing that. So one letter for the petitioner, one for the beneficiary. I have samples of this, I believe, in the Ultimate Marriage Green Card Guide. Go to www.marriageimmigrationlaw.com, marriageimmigrationlaw.com, and I think I put samples in the addendum at the end of the ebook that goes over this. And so for those of you looking into fiance visas, marriage visas, all the like, check out the Ultimate Marriage Green Card Guide. We have a lot of good free guidance in there that give you an idea about strategy and what's going on, how things look. Go to marriageimmigrationlaw.com. But any recent updates on what USCIS and the State Department are doing to reduce the backlogs at the U.S. embassies and consulates? Unfortunately, nothing worthwhile yet that I've heard that's going to make a difference in any way. Right now, the situation in Afghanistan, you could bet that their hands are full with dealing with that fiasco and trying to help those people. So the priority for everyone else goes down. But nothing that they're doing that I know of to help people stuck in these huge backlogs, unfortunately. But thank you for your question. Mirak says, tell me about the E2, please. Well, I have a lot of videos about the E2 investor visa on my channels, either JQK Law channel or the JK Clips channel. But essentially, the E2 visa is an investor visa, and only citizens of countries that have a treaty with the United States are allowed to use it. So, for example, the U.S. has a treaty with the country of Turkey, where Turkish citizens can invest and start businesses in the United States and stay and operate that business for the U.S. almost indefinitely. You keep renewing it as long as the business is going. There's no green card that comes from it, but it's something that's really helpful. A lot of people do. Now, again, I got to go back to the treaty aspect. Not every country has that treaty, and major countries like India, China, Russia, Brazil do not have this treaty. So if you only have a passport from one of those countries and many other countries, you cannot use the program. But if you have a second passport or passport from another country that does have a treaty, you can potentially use it. Next question that comes up is, how much is the investment amount? Everyone wants to know that. Well, there is no minimum investment amount for the E2 visa. The rule is just you have to invest enough based on your business plan and what you want to do, that it makes sense the amount of money you're doing. So I always tell clients, listen, I mean, I don't really take on E2 cases anymore. I refer them to one of my colleagues, but like when I was really active in it, I would say if you're going to create a car factory, you're going to need billions of dollars. So that's that. But if you're going to make a small restaurant in a rural area of the United States, you might need 50,000, 100,000, depending on what it is. If you're going to make a restaurant in the middle of Beverly Hills, a very expensive place in the US, you may need at least $1 million because of the costs and stuff. So it really depends on the investment amount of what your business is and what you're trying to do. If you're seriously interested about that, just contact me. I could connect you with my colleague who works on these. But I hope that information helped. C user asks, I got a friend who is still waiting for an N400 interview after citizenship. Biometrics were waived by USCIS. N400 received April 2020. Is Mandamus the way to go? I don't think it's the timeline is too late now, a year and 4 months. I would, if you want, you could always file Mandamus, say it's going too long. But with the delays happening all over the place, I don't think that's too abnormal to wait a year and like 4 months more. I'd probably wait till the end of the year. Go to USCIS.gov to see what their estimated timelines are for the field office that would be doing the interview, because that's different for every place. But it's up to you. You could always file your friend could file mandates if they want. I'd be hesitant, but I need to know more facts about the case. There might be some complicated issues in the case that require more time. So that's about that. But it's a personal decision if you want to go that far. But I would need to talk with the person to see what's going on. I don't handle the lawsuits myself. I have colleagues do that. But it's a really fact-based and personal decision to file a lawsuit. But thank you for your question. Steve says his case is outside processing times per USCIS processing time for Los Angeles. Yeah, in Los Angeles, I'm getting like citizenship cases done in like 3 months, which is crazy. I haven't had that happen for years. So yeah, a year and more for Los Angeles is bad, but it depends on the case. Like, what country is the person from? What kind of history do they have? You could try contacting USCIS.gov to do a case status request because it's delayed. Sometimes I say contact the local congressperson, but they're not really answering stuff. I have things where I have to contact the congressperson for delays in their processing or helping with expedites, and they're not even responding. And I assume, it's a strong assumption, that because of the situation in Afghanistan, we are having thousands of people make these kind of requests and they're overwhelmed. So It's a personal decision. They should really have a lawyer talk with in private about this, help them through this step. But thank you for your question. If you do ask asylum blank space filing, I think what you're referring to is an update that the Trump administration did, where if you filed your asylum case and any of the boxes were left blank. For example, they ask how many children you have, or they ask you to list your children, and you might have no children, so you leave that part blank. They would reject these cases, saying you shouldn't have left stuff blank. You should have wrote NA, not applicable. But the new administration and court cases and stuff have undid that. So for those who are rejected, they could go back and try to fix it. It's fixable anyways. But going forward, that's not a problem. But that's what happens with USCIS. Things go forward, they go backward, they constantly change. It's very difficult to see what's going on. But right now, they're undoing that massive failure of the idea that they have. Sierra's asked, when you file for Mandamus, do you get your money back when you win your case? Normally, no one gets their money back when they file a lawsuit, so I wouldn't expect that, practically speaking. Normally, the case is going to be settled or become moot in a way that you're not going to get a win, if you will, because the USCIS might just send you an appointment notice, interview notice, and that fixes the case. All of a sudden, the case becomes without merit, and that's it. You didn't win it. I mean, you did behind the scenes, you did, but they rarely do people get their money back in lawsuits here, so I wouldn't expect that. All right, Terry asks, I have a temporary green card and it expired in November 2019. USCIS gave an 18-month extension. It is expiring. What should I do? I travel internationally. Well, I talked about this, Terry, at the beginning of the show, that USCIS is now giving 24-month extensions instead of 18. But what you have to do is schedule an info pass appointment with USCIS. So you go in person, show them your valid passport and proof that you have a case pending and a need for travel, and they'll stamp inside your passport that you have a green card. They made the process for doing this very difficult because you have to call and set an appointment. They made that really difficult. But if you get past that and eventually go to the office and get the stamp, that'll be proof of your status for traveling and for work. Ayo asks, what's the difference between the priority date and the receipt date? My I-130 said priority date February 2nd and my receipt date is March 15th. My I-130 is Nebraska. Any advice? So the processing location doesn't really make that much of a difference, but normally the priority date and the receipt date are the same. The date the government received and the priority date is the same. There's some employment-based cases where you could have a priority date that goes before that, when the permit application started, when the I-140 was filed. For employment-based cases, I-140 is the priority date. But for the I-130, if you're doing a preference category case, just whatever the priority date is, go to that. But priority dates don't always make a difference. Depends on the case type. But essentially, the receipt date doesn't make a difference. If you need to take a number, a date that makes a difference, for most cases, the priority date, so you can go by that. Maverick asks, can you apply for citizenship while having a pending I-751? Yes, I do it all the time. Now, I want to review your case to make sure everything is proper. And some lawyers say online, I've seen YouTube videos that say you can't do that. But 100%, if you have an I-751 case, it's pending, you could file for U.S. citizenship. I almost always do that for all my cases that are 751 pending, so they can get the process done sooner and get their U.S. citizenship. Sometimes the I-751 takes so long that they actually schedule the citizenship interview beforehand, and we take the opportunity and try to push it. And usually they already have it prepared to finish the I-751 and citizenship on the same day for the interview, so you get that out of the way. So that's something you should definitely look into. Amon asks, due to naturalization of my mother, my petition was shifted to F1 and from F2B automatically. Priority date will be current. I'm in the U.S. Using B2 for leisure. Can I apply for AOS after 9 days of entry? There's a lot going on there. I can't tell you whether you can or not because I don't know enough of your case. But if you did intend on applying for a green card and it just worked out that way, it may be possible for you to apply. But to tell you whether you can apply or not, there's just a lot of analysis I have to do in your background to see what's appropriate you want. So, definitely schedule a consultation with attorney talk in private. It may be possible. You could keep the F2B status by notifying the government. There's a law under the Child Status Protection Act that allows you to keep the F2B category, preference category, even though you're technically an F1 now. And the reason is the F2B category, adult children of green card holders, moves faster than the line for adult children, single adult children of U.S. citizens. It's kind of a weird situation, works out that way. Kata asks, can I change, sir, can I change my B1, B2 visa to study visa in the US? It's possible. There's headaches related to it, some complications, but it's technically possible to change from a tourist visa to a student visa, an F1 student visa status in the United States, but I think that's all with a lawyer to go over that. Jordan asks, is USCIS critical about interracial marriage, black and white? No, they're not critical, but you know, they have a list of stuff that they train you. If you have like 10 stuff that they're suspicious about. If you have like 4 or 5 of them, there's a problem. But one of them, like being of a different race or color or different ages, it's not that big a deal. It really looks on the whole situation for them to judge you to see what's going on. So it's not, it's not even an issue. Now, I do mention it when I have, because I have couples, I have one right now where they're different races. I told them, if it's just that one thing, it's fine. But if your age is really different, and you know, you guys don't speak English, both of you, that becomes a problem, and you're from a different religion, and there's other issues and no relationship courting history. If you add a bunch of stuff to that, where those bunch of stuff we add is the bad stuff, like being different races doesn't make a difference, yeah, that's bad. But that's, you know, you have to have a lot of negative information to really hit you. Just being of a different color, different race is not something that's going to be a problem in most cases. Unfortunately, with that, I might throw this out. I'll catch you all again next week. God bless. Bye-bye. I hope you enjoyed this educational video. We have a second channel with much more information as well at JQK Immigration Clips. Please check that out. Also, you'll find our social media site has a lot more videos, images, and information about the US immigration process. Please check those out on the various social media websites.